on 105 and then a proposed instruction in the event that Mr. Copeland does not grace us with his testimony beginning Monday. So I'm just looking at those right now, and those look pretty good to me. I don't know if y'all have had a chance to look at them or not. I don't know if y'all come up with your own instructions for us to ponder, but this is the only new one I've gotten so far. I think y'all were all hard at work until you just came in on something as well. So if y'all want to forward what you have, that would be great.
Okay, ladies and gentlemen, put a 1 in the chat if you can hear me. Put a 1 in the chat. Put a 1 in the chat if you can hear me.
Your Honor.
Yes.
Regarding the jury instructions, I think Ms. Westmoreland is working on typing one up.
Okay.
But I'm just going to say it is very lengthy and
Okay.
also addresses a lot of, it's going to be very lengthy. I'll just put it like that. Because we feel that it needs to address every alleged overact and who it would not apply to.
Okay. Well.
All right, guys, I am back.
We could possibly come up with. We could possibly come up with a general charge, but then it would have to be repeated for every overact for every individual who is not charged substantively with that overact.
Okay.
Is that fair?
Why don't you give me the really detailed one and then also a more general one? And it may be that even if we don't use the really detailed one now, we use it, at the end of the trial when we're giving them all the instructions. But I'll take a look at both of them. And I know we are going to need to sort of give each other a chance to look at what's been cross-proposed and then make edit, come up with something else, and then actually figure it out, which, maybe can happen in the next hour and a half or 2 hours, maybe can't. But this is finally a good start. So, do you need a little bit more time before you send whatever you're going to propose? Okay.
To do it right.
Like 30 minutes? Like how long?
Just to do it general. I think that we definitely can do this. And I think that that it deserves, attention. And as you mentioned earlier, that we need to be specific so that the jury understands what we're trying to, what you're going to convey to them. With that being said, I think that it's going to take longer than an hour.
Okay. So I guess I'd rather have it late and good than not at all. But I am having a really hard time understanding from not necessarily everybody, but not simply one person or one side either, why when I say kind of A, over and over again, and B, with a week or more's notice, I would like for y'all to be working on this and provide it to me. Why lots of this is still
Lingering.
not provided in a timely manner. And y'all don't have to give me an answer, but I would like for y'all to stop doing that. Okay? Because we are in the middle of this trial, as y'all all well know. And, you know, one of the complaints made by the defense is, man, the jury's been out so long, they're not even going to have any idea what we said before. And the longer we take on everything, the longer the jury stays out. And I'm having the jury back on Monday at this point. And it should not have been a surprise that we were going to talk about this today. And y'all should have already had whatever you wanted to propose ready and in final form. So let's please try to be more timely with the tasks at hand. Okay. Okay.
I guess I'm wondering how often
All
is
right.
this judge going to have to
So,
keep reminding
I think
the
maybe
prosecution
we'll all be
and the
here really
defense,
early
well,
on
pretty much
Monday.
the prosecution, of having things filed in a timely
I'm going
manner.
to give y'all all orders so you can get in early, and we're going to be here starting at I may need to find out from the deputies how early we can have our defendants here and ready to go. I mean, I was thinking 8 a.m. and I know that means an early day for everybody, but since we can't spend 3:30 to 5 talking about this, what can we do? What's the earliest we can do? Can we do 8 a.m.? All right. We're going to be here at 8 a.m. on Monday. And we're going to, finish, and y'all work together over the weekend, over Friday and the weekend, to the extent you can, to narrow down any disagreements or discrepancies and bring to me only what still needs to be hashed out Monday morning. Okay. Yes, ma'am.
Judge, I just want to make sure, so as our position is that some of the instructions would be better given at a different time than Monday. Is it a certainty that the court is definitely going to give it at that time, or is the court open to hearing any, law or any?
It's not a certainty, but it's a probability. And yeah, if you've got law, I'll consider it. But you don't have to wait till Monday morning to send it to me either. But it is a probability.
Thank you.
Okay. Yes.
Your Honor, do you want objections to the state's proposal or just the re-proposal so you can then evaluate it? A separate proposal in writing.
Right now, I don't think necessarily want objections. What I'd like is for y'all to try to work together on something.
Okay.
I mean, if you think there's some entirely incorrect legal concept, but I'd really rather y'all try to get together on it first.
I do object to it, but I think that makes sense because I could do all of the objections.
Okay. All right. Thank you. Okay, so given that we are not able to sort out jury instructions right now, and I think we have dealt with all of the evidence that we think might be, objectionable, that we need to hash out beforehand with regard to Sledge now. Is that right?
I believe so.
Okay.
I saw some inquiries over the time that we wrote regarding a couple of exhibits maybe that were.
Yeah, and I don't know if those were objections as much as they were just, we need to sort this out.
Right.
So
certainly we would not be entering the same piece of evidence under two different numbers.
yeah.
We would just wanted to make sure that we got.
Yeah, no, I mean, so yeah, just take a look at that and yeah. Okay. So yeah, I don't think that was an objection. That was just kind of an observation. All right. So then who's our next witness that we can get through evidence on? Do our motions in limine on.
Quickly. The judge is not going to wait all day.
Oh, and Miss Love, I know that you have now given to defense counsel the detailed list, right? But have you given that to the court? Didn't you give them something?
I shared with them the bucket of physical exhibits for Sledge and a list from yesterday. And I'm about to send over another bucket for another witness. So as opposed
Good.
to be able to give all of the exhibits themselves.
Mm-hmm.
That's what.
So are you then not just, so I understand, are you re-providing the actual exhibits?
That's what I had.
Okay. I mean, that's fine. Fine with me. What I want to have happen though is, have you now only done that for Sledge and you're about to do it for one other?
The actual exhibits?
Yeah.
Yeah, because Sledge was the next.
Right. Okay. So what happened to the tranche of the first 30 witnesses?
So I was working on that.
Okay. They were due yesterday.
So that's what I'm.
Come on, Miss Love. Come on. The judge gave you a schedule. This is not Judge Glanville.
That's what I've been working on.
She really hadn't said much.
I haven't said much.
Ah, she haven't
She
said
was
much.
speechless for a minute. And now she says that's what I've been working on. Okay, so
The judge called her out. Oh my
and
goodness.
maybe you're confused about what it is that I want produced. If you have got if all you're using, for example, with Thomas Burnett is demonstrative pictures of the infinity, and they have all the demonstrative pictures of the infinity, and demonstrative pictures of the infinity serve, XYZ date as, item number 73B, that's fine. I don't expect you, unless it's easier for you, to reproduce those things. I do want you to identify it specifically enough that they can go, oh, here are the 10 pictures she's going to use. And I hope you don't have 10 pictures because that would be excessive with this one infinity representative. So does that help a little bit? But I do want it to actually have happened for 30 witnesses at this point in time, because we can't.
So
the way to operate this trial is not witness by witness at this stage of the game. Okay. So do you need clarification beyond that?
no, no, Your Honor.
Okay.
I have all of the exhibits in folders.
Okay.
So what I was doing was trying to extract the specific ones. So for the 30 witnesses, we have the exhibits in 30 folders.
Okay.
And what I had done was label them and extract
Okay.
relevant ones and send them over.
Okay.
And so I won't do that. I'll just go through the folders and put it in a table, because I was actually going to do that for the ones that are listed. I was actually sending the list yesterday. Mr. Atkins sent it for me just to say, hey, here's what we're sending you. But
Okay, whatever is easiest, and I mean, if it's easier to have them each give you a thumb drive, that's fine too. I mean, logistically speaking, you know, I just want them to know with some degree of specificity, here is the actual evidence they are going to be using with this witness, not social media. But
got it, I understand.
what social media? Okay. But they should have been served at this point in time with everything you intend to use with every witness.
They have,
Okay.
and understanding the court's instruction about making sure about anything that the court told me to give to them by noon. So both of those.
Okay.
I understand. And yes.
Okay. And so when can they expect the next 27 or 28 witnesses info about which exhibits?
So I'm just gonna upload.
Okay.
Because it'll be probably quicker to upload them to a Dropbox link than it would be to sit and, or maybe we can have some team members. Some uploading, so.
Okay. And can you share it with the court as well, just so I can have it as well? Okay. So by the end of the day?
As in an hour and change?
I mean, I figure you're going to work past 5.
I have.
So what I kind of mean is by midnight. Okay. All right. And then is everybody okay? So are we ready to work on another witness's chunk of evidence that we think might be subject to motions in limine?
You gotta, if
Yes.
the court will give me a minute just to get my list.
Okay.
Your Honor,
Yes.
may I bring up another potential issue?
Yes.
So it's my understanding and belief that that there may be some outstanding Brady material regarding Antonio Sledge.
Okay.
Brady to include impeachment.
Okay.
My understanding and belief is that the state may have met with Mr. Sledge and he may have said some things that would fall under Brady in a prior meeting.
Okay.
Didn't say anything. I don't know what part of that
Okay,
meeting.
so do you two want to huddle together and maybe Mr. Shark can share with you what he thinks got said and then you can confirm or?
Yes, would the court give us a moment just to step outside now or do you?
Sure, or you can.
I don't know what was said.
Okay.
I don't know specifically what was said.
So do you have any reason to believe Brady material or impeachment material was shared then? Or you're just saying they had a meeting and so there may be Brady material that stemmed from it?
My understanding is that there may be Brady material.
That stemmed from it, but you don't know what it was.
If I knew what the Brady material was,
Okay.
then I wouldn't have an issue.
Well, since there, Mr. Sledge's attorney was present at the meeting. So if Mr. Sharp has spoken with him, or I don't know where the idea that there was Brady material, there's no privilege. So Mr. Sledge's attorney is a ready source of everything discussed at the meeting.
All right, maybe
I don't-
would Mr. Sharp, would you be willing to share privately with somebody on the defense? Do you have the same issue with talking to Miss Love that Mr. Steele does?
Wow.
I don't.
Okay. Would you have an issue with sharing with her maybe the source of your information? And if you do, that's fine. But
I prefer not to.
okay.
Um,
All right. She seems a little in the dark on what might be. I mean, I don't know.
doing.
Not the source, just if he would,
Children,
just
children.
the content, I don't know what he's talking about.
I don't think he does either. Apparently he got some tip that Sledge may have provided Brady material, and that's about all you know. Is that right?
If there is anything inconsistent with what Mr. Sledge has signed in his plea agreements or anything or said before, that would be
That would be
considered
impeachment and
would-
therefore Brady. Yes. So you have reason to believe that he may have said something at the coffee shop inconsistent with something he already said.
I'm
Can
asking.
you be more detailed with regard to which thing it might be inconsistent
I
to, or you just don't know?
don't know,
Okay.
and that's why I'm asking.
Okay.
There were there were 4 people in the meeting. If anyone's recollection of those set of events are different than mine, I'd like to know what they are, because mine is not that he said something inconsistent. And as I said, the people who were there are me, Mr. Sledge, Lieutenant Lancico, and Mr. Sledge's attorney throughout the entire time there. So.
All right. Well, it's really the relevant issue is not who was there. The relevant issue is, did Mr. Sledge say something inconsistent at the coffee shop with whatever he has told the state or law enforcement previously? I guess any of those 4 people could sort that out. The best two would be, well, the best one would be you if you were the prosecutor there, because I mean, I don't know what else to say. Maybe there's nothing, but maybe if you've got notes, or you and your investigator get back together and think it through and try to figure out whether he said anything that's inconsistent. And I mean, I don't know what else to do.
I know.
It's
So,
like pulling teeth with this lady.
We will search our collective memories.
Okay.
And I am really interested in speaking with Mr. Sharp about what he is talking about, so that I can understand where.
All right.
So
I'm not
I
sure he knows.
Different. Somebody has said the word Brady or something, and I don't. I will talk. We will.
Okay.
Search our collective.
Something inconsistent.
Did anybody take notes? I mean, we had 4 people. There, nobody took notes. If there was a report, if there were notes taken, if there was a recording, we would
Okay.
have something to review to determine whether or not there was something that should be provided to us.
Okay.
Okay?
I don't know whether that happened or not.
I would, if I had I did not record our meeting, our conversation, because I would have turned that over. I did not record our conversation.
Okay.
It was literally a conversation,
Right.
and that's it.
Okay.
Sorry, I missed it. I understand then that not a single person took any notes of that meeting.
So I don't know if Ms. Love can speak to what Mr. Sledge or Mr. Sledge's attorney may or may not have done.
I'm asking from the state. It's the state's obligation to provide it to us. We don't have to go out and talk to
I
anybody.
understand.
All right. So I'm just inquiring as to whether there are any notes, and I'm just surprised. Well, I would like an answer as to whether or not any notes
Were taken.
Thank you.
Two things. I did not take notes. I talked. Lieutenant Lancico, as she sat there, she looked around and listened and looked around our surroundings. We were not within Fulton County.
Okay. So no notes?
No.
All right. No notes.
I would not. Well, there are no notes. I did not take notes. She did not.
Okay.
My notes are not something, my investigator's notes would be something to which either of the defendants would be entitled. My notes would not.
Because they're attorney work product.
Yes.
However, if there's something Brady in your notes, then as you know, you need to provide it. And if there's something Brady that you hear, then you need to reduce it to writing and provide it. We talked about this before, you know that.
Yes.
And so you are maintaining that no, you didn't take any notes. No, your team didn't take any notes. As far as you can think right now, nothing Brady impeaching was said. You will give it some further thought along with your
attorney.
Sure.
Make sure that
Okay.
his memory was
All
mine.
right, that's all we can do at this point. Thank you for raising it so that they can think about it some more. Yes, sir.
Your Honor, you asked the state, pursuant to my request, whether there was any Brady whatsoever from any fashion, not only impeachment evidence, but exculpatory evidence. And the state said, let me think about it. This, I believe it was yesterday.
Right.
And I'm presuming by the silence, there's nothing.
All right. So I think I gave y'all, remember I told you to huddle with your team, not just on Brady, but on anything that is discovery that you intend or think you intend to use that they might not yet have. And I think I gave y'all until Friday to finish that huddle and get that answer back. So yes. So I think they're still huddling on that. And by 5 p.m. on Friday, if there is anything, please detail it in at least an email, in writing some way that you send to the defense and to the court.
Thank you, Your Honor.
All right. All right. Any other
Why do I think there's going to be more
issues before
Brady
we get
material
to the next witness that
popping
we
up?
might have evidentiary things
Why?
to sort out on? All right. Okay. Okay. Who's the next witness now that we should turn to? To sort through their evidence. So we've done Sledge and Zachary. Then also on that list, coming up after them is Detective Thorpe with the Kendrick interviews. Have y'all already hashed that out?
So so Your Honor, I'm glad, thank you for reminding me. So with respect to the Kendrick interviews, we needed to bring to the court's attention, I don't expect to be playing them or getting into them by next Friday, but we had.
Okay, that's fine. But remember, we're not doing this week by week anymore. We're doing as much as we can possibly get through beforehand. All right, but anyway, okay, go ahead.
We had previously, Mr. Weinstein, Mr. Kendrick had filed a motion to suppress his statement. And the Honorable Judge Glanville heard arguments from Mr. Weinstein.
But didn't decide it?
He decided it as to the portion of it beyond a break in the interview.
Okay, and that part got suppressed?
So that part got
All right.
suppressed. But as to the portion before, I believe there needs to be a Jackson Deno hearing on this. There's no argument about it because he did not suppress the part before. My witness was here, but he was permitted to put him on a stand. So,
Okay, so a part after some break was suppressed. Was an argument made that the entirety of it was should have been suppressed?
no, I think that, no. Mr.
Okay.
Lasting argued that just,
Okay, well then it seems like there's not anything pending. Is that correct, Mr. Howell?
Sure, I am jumping into this.
I know, so am I.
I will need to check with Mr. Watson. I should have an answer.
Okay, all right. All right, so we think that whatever wasn't suppressed is legitimate to be presented, and so there shouldn't be other issues as to his statement or statements. Is that right? Is it more than one interviews?
there's more than one part of it, but no,
There's only one interview, and obviously you're only using the unsuppressed part. Okay, so, and that'll be Miss Detective Thorpe's testimony at that point in time.
So there is, so we will need to have an argument because there's a.
Speak up a little bit, because I'm sure they're gonna say they can't hear you.
There is a second one.
Okay,
And so the argument may be, hey, we needn't reach that second one because in the first one, this break occurred and everything beyond that point should be suppressed.
uh-huh.
I would have a different argument, but we have not even looked, we got to one interview.
Okay. And you would like to use the second interview?
Yes.
Okay.
We would object.
Y'all, this is just, was there no deadline for filing challenges like motions to suppress? Okay, I'm going to need that motion. If there's a motion to suppress the second interview, I'm going to need that ASAP, and not just this interview should be suppressed. You tell me why. You tell me the legal basis. You tell me the facts that back it up. Give me a specific motion to suppress, a particularized motion to suppress.
But what would the opinion that original order covered everything past?
All right. Anybody be able to point me quickly to date of original order?
It was March 4th.
Okay, thank you.
This year.
All right. Yes.
Let's go with March 18th.
All right.
And I just emailed it
Thank you.
and the report.
All right. So I'll take a look and see what that seems to say. All right, the next thing would be, or the next witness would be Mr. Bean with text messages.
So, Judge, I think since we talked about Mr. Zachary's interviews, I think that Mr. Bean won't be the next one. Mr. Zachary would be before Mr. Bean. And there are social media postings. I don't think that there is going to be any kind of an issue, but just I can name them or send them, share them.
Well, if you'll share them with the defense, then the defense can see whether they've got objection. Does the defense think at this point that they have objection to Mr. Bean's text messages or social media? I assume y'all know what she means by that.
Judge, I don't, so unless something in particular happens to allow us to introduce it, the state is not going to, I don't anticipate using those text messages of Mr. Bean.
Okay. All right.
Well, she doesn't sound certain that she's not going to use the text messages of Adrian Bean.
Can you send me that?
He's not going to give her much anyway.
Your Honor?
Yeah.
May I add to that? Just to be fair, those text messages.
I don't know. It looks like we having an issue with the stream. Stand by, ladies and gentlemen. I think we should be good.
I don't foresee a circumstance, that occurs.
Yeah, I don't foresee a circumstance where that would be permissible either. All right.
If an attempt were made to make an argument that is directly refuted by something that was suppressed, I might ask the court, hey, Your Honor, this argument was made. This is not true. We have a reason to believe it's not true. Here's why we think that. Would the court consider X or Y or Z as a curative?
I mean, if you want to provide me some really specific case law that says I can do that, sure, but I wouldn't waste your time on that right now. Okay, so Bean will probably just be some social media postings. So, I mean, if I had the more detailed list, I could.
I don't, right now, it would be testimony.
Okay.
It would just.
All right. I'm just trying to figure out what we can make progress on while we're here. Kenya Morton interview.
So Kenya Morton would, it would be her interview to impeach her if necessary. She is listed as an alibi witness of Mr. Kendrick.
Okay.
And so
Okay.
her interview is the
All right. And everybody's got the interview. Anybody anticipate, assuming they're going to impeach, that there are other issues with her interview that I need to think about evidentially right now?
and we have impeachment, but it will be impeachment and substantive. That just, since there was an issue raised, but that would be the only thing with Ms. Morton.
Okay.
And the other pieces of evidence that would be used with Ms. Morton have already been introduced.
Okay. Easy enough.
Introduced through another witness.
Okay. So I've just looked at the very first paragraph of the order on Mr. Kendrick's statements that's filed March 18th of this year. And I haven't looked at the end of it yet, but it certainly says the motion to suppress was as to an October 6th and an October 12th statement. So I would imagine that he covered both, yeah, continuing through the entirety of his October 12th interrogation or suppressed. So yes, that second one has already been ruled on and is not allowed. So it's the October 6th one prior to the 2:16 p.m. mark. Okay. All right. So that answers that. That one was an easy one.
There may be, I have to refresh my memory, there may be some Bruton issues in that it's a law enforcement statement. I will look at it though and alert you.
All right. So we would definitely need to sort that out before presenting it to the jury too. Okay. So yes, thank you. And just share with the state whatever you think about that so that they can have a response prepared. And normally Bruton, not necessarily normally, but oftentimes Bruton issues can be cured by redactions. So if you've got proposed redactions that would cure it, that would be immensely helpful.
We'll send over anything.
Great, thank you. All right, and then next, at least on this list, is Mike Sprinkle, who, I mean, I don't know what all, is he going to be testifying to stuff that's already in evidence or new stuff too?
A combination of things because ADA Sprinkle was after the DA's office was given a case, ADA Sprinkle went and continued to research and work on it.
Yeah.
And as a result of what he found, different persons were charged.
Right.
So he would be speaking to both jail calls that he found.
Okay. And then is he going to testify to the contents of those jail calls? And
he would play them, not.
okay. He'd be like, I found this jail call and it's between these people or, okay. And you'll give the defense, if you haven't already, details of what those jail calls are, when they occurred, et cetera. Okay.
Yes, and also, for instance, Martinez Arnold is a witness further down.
Mm-hmm.
I don't think he's on this list, but he is a witness that we are intending to call. So we would not endeavor to put, before Martinez Arnold testified, we would not be endeavoring to put his jail calls in.
Okay.
But for instance, Mr. Stillwell's, we would. Mr. Sledge, he would have already testified. So anything that we needed to impeach him on or anything that he didn't, Mr. Sledge
Okay.
denied knowledge of or refused.
All right.
So,
All right.
So Your Honor, my client has about maybe a dozen jail calls listed under Mr. Sprinkle in the spreadsheet that was shared yesterday by Mr. Adkins. They had previously identified, I think, 4 calls, and so there's additional calls. I still need to review those calls.
Okay.
Because that's the first time they've been specifically identified beyond those 4.
All right. And I mean, sometimes people continue to make calls and Mr. Sprinkle probably continues to listen to them.
Well,
I don't know.
From 2015, but
Oh, okay. Well, there are a lot of jail calls to get through with some people. So, okay. So sure. We're going to have that whole week in another week that starts on August 19th. So maybe we'll be doing that then.
yes, Your Honor.
Okay. Thank you. All right. And then it looks like there's a series of custodians of cell records. Do y'all anticipate objecting to those people?
Mr. Williams,
How about for Mr. Kendrick? Mr. Nichols? Mr. Huey? Okay.
Caveat, presuming of course that we've got all of the business record certifications. I think we probably.
I would certainly hope that, but yeah, y'all will have certifications for this. All right, so those will be easy witnesses. And then Bernie, this was the guy we talked about yesterday, but you were saying the report he's going to be providing at this stage of the trial is not that new-ish one. It's something else, right?
We would not be endeavoring to have him talk about the two new ones that he plotted. We would
Okay.
only be presenting the plots of the cell phone numbers that we had previously provided to the defense.
Okay. All right. And then we've got a firearms analyst, which of course there'll be lots of cross, I would imagine, maybe not, I don't know, on the stand, but do we have any like motion and limine type issues that y'all know of with regard to the firearms analyst? Things I could be thinking about beforehand?
Unless there's recent United States Supreme Court opinion, I have to refresh my memory whether there's a surrogate witness, but otherwise, no, it's nothing from us.
Okay. All right.
I'm sorry, I couldn't hear all of what Mr. Steele said. If you could.
Do you mind repeating that?
Not at all. Unless like a crime lab person left the office and this is another person coming in to say we reviewed notes, but he or she didn't do the testing. There's a new United States Supreme Court case, I can't remember, but came out within the month.
Yeah.
That talks about that's a Constitution Clause violation.
Right. This is the same person that actually did the analysis to begin with.
So both Mr. Weitzel and Mr. Voss physically analyzed them.
Okay.
Neither are still with the GBI.
Okay. But they're going to be the ones that come and testify.
Yes. I
Okay.
don't at this point, unless something has happened to them. I haven't.
All right. Well, maybe get somebody on your team to check and make sure they're still lined up. Okay. Super.
Your Honor.
Yep.
As we go. No, not that. There was one set of instances, and this is something that will be included tomorrow, but just as I'm thinking about it and looking down at the next few witnesses.
Mm-hmm.
So we have provided crime lab photographs, APD photo lab photographs for the intrinsic acts, the shootings that occurred after the murder of Donovan Thomas.
Okay.
One of them, I think April the 28th, we provided a crime scene technician's report of a set of photographs.
Okay.
The actual photographs, the lab said it could have either been affected by the hack or what. The description of each of the photographs was listed in the crime scene report. I've asked the lab, do you all have a physical copy of whatever you uploaded to your server that may have been affected by the hack? I have not received anything from them.
Okay.
And that's something that while I looked at it as we were sitting here, that I wanted to.
Okay. And this would be photos from which crime scene?
It is the one Adele Avenue, 1428 Adele Avenue. The crime scene that is 118-0462, 15118-0462.
All right, and they no longer have the originals, or what's the deal?
They,
Because the description of the photo, I don't.
I don't know. They've been looking for me. So
Well, do y'all have copies of them?
no. So that's just it. We didn't have the photographs themselves. If we had a copy of them, that would be great.
Right.
But we were never given the photographs themselves or a disc of the photographs themselves. We just got an email or a response saying, we couldn't locate this one.
And this is APD
Yes.
took these photos?
Yes.
Okay.
Okay, guys, I want to break away from the court coverage for a minute because some of you are asking me. I don't want to be very clear. I got a call early this morning from a YouTuber. And no, it's not who you think it is. And I won't even say their name more so. I would just say that apparently this YouTuber who's covering the YSL case, and maybe you guys can put two and two together. He was mentioned, and it's a he, it's not a she. He was mentioned in the by Lil Woody sometime early on when Woody was doing this live stream. And he essentially said to me, he said, you don't support black media. You work with the white folks. You don't support black media. So I first of all, he threw me off. He's screaming and everything. And I'm like, wait a minute. First of all, calm down, Playboy. Don't yell at me. And then he couldn't back up what he was talking about. So apparently in his mind, he thinks because I'm a person of color that I should parrot a narrative that's being promoted by, I guess he assumes he's a YouTuber, but I guess he views himself as black media. So I should parrot something that he's doing or maybe someone else is doing. And he is connected to the other person that you guys suggested earlier in some way. Those two had their a head bump. They bumped heads in the past. So then it got disrespectful. And then at that point, I said, first of all, we can see each other whenever we see each other. We're not doing this phone gangster stuff. I don't do phone gangster stuff. I don't do that. I'm not built like that. We don't talk about things on the phone. We just deal with it, whatever that is. So then I'm wondering, so where is this notion that I don't support black media? I don't know if I've ever been accused of not supporting something that I'm a part of, black media. So it was kind of weird to me that he came in, he was ranting and everything. Then he says towards the end, I said, are you doing this so you can create content? He said, yeah, come on my platform. Let's talk about it. I'm like, dude, I'm not coming to your platform. It's not happening. So it's just one of those things where he might be sitting back wanting and sometimes these YouTubers like to pick fights and everything, but I would never go on his platform. He would never get on my platform. But I don't know if he was sent by someone, but it was just weird that he was saying, you don't support black media. What are you talking about, jerk? It was just weird. So it's not who you think it is. Right. Exactly. Right. You don't support you because I guess I was on court TV a couple of times giving commentary, talking about a member of the hip hop community, Diddy, and he might have seen that, or he may have seen me on another platform. There may have not been a black platform. I guess he assumed because I was on a non-black platform that I don't support black media. What an ignorant thing to say. But more importantly, I think he's I don't know, I can't even make sense of it. But in any event, he called me and was just doing the most. And I'm like, okay, dude, All that sounds good over the internet or not even a phone call. But the minute he said, come on my platform, I'm like, okay, dude, that's not happening. So if the purpose of this call was to get me on your platform, it's never happening. You can rant, you can cry, you can. First of all, you probably don't have a National Association of Black Journalists media card. You probably put no work in, none, because a lot of people are building their career off of this particular case. And I get it; it's a high-profile case, but there's so many other cases out there, so many other stories to cover, so many other stories around, even in his own city. Like it's just weird. He's in wherever the 443 area code. I think that's Baltimore. He's in the Baltimore area. There's definitely cases happening in the Baltimore area. I don't know if they allow cameras in the courtroom. I don't know if that's the case, but he still can tell stories. I mean, tell the stories of his own city. So, I mean, it just is weird. He said, then nobody knows you. I'm like, you're actually calling me because you feel I don't support Black media, which I thought was kind of crazy, but I just thought it was interesting. I just want to say that, yeah, if he ever thinks I'm coming on his platform, it's never happening. I won't be supporting your media, black man. I won't be coming on your platform, black man. As a matter of fact, you can go around and look at other Black platforms that I go on. So I don't know if it's a matter of I didn't come on this platform. Oh, you know what it is? I know what it is. I know it. I just thought about it. He's been asking me to come on his platform to discuss the case, and I have not been on this. I declined to get on his platform because I just don't like the direction he's going in and telling the story. I did a call in one time, but as I watched his platform, I realized that he's trying to frame a particular narrative, and it was a lot of hyperbole built into that narrative. And I was like, nah, I'm not going to be a part of that platform. And I do remember he called me maybe 3 or 4 times. And when are you able to do the platform? And I guess he needs an interview. He needs some love. He needs some love. You need a hug? You need a hug, Playboy? 'Cause other than that, that's all you're getting from me. You want a hug? Because I'm not getting on your platform. It's not happening. But that's it, man. Don't let nobody bait you out to try to bait you into getting on the platform. Because he wanted me to take the bait. I'm not getting on your platform. I'm not getting on your platform. How about you get on a plane, fly to Georgia, come to Fulton County, come to the courthouse, and do some work. Do some work. Then he said, I'm gonna see you in the court. You ain't gonna see me anyway. You wouldn't see me if I came in your neighborhood. How about that? You wouldn't see me if I came in your neighborhood. If I stood in front of your project door, you wouldn't see me. So all that, wait till I see you, boy. You ain't gonna see nothing. You're gonna get a bad decision. That's what you're gonna get. And let me just leave it at that before I turn up on that cat. But sometimes sometimes you gotta have fun with these people. Sometimes you gotta have fun with them. But I'm not even saying your name. I'm not even saying your name. I might tag you. I'm gonna tag you, and so you'll see me talking about you. But I'm not even gonna say your name because at the end of the day, you're not relevant. You're not relevant. I don't even think you're Black media. I think you're the ops. I think you're the police. Yeah, I'm with the crap. But anyway, let's get back to the case, guys. I just wanted to go in and kind of just talk about that briefly because I know some of you came here and wanted to know what was really going on with that. And I just wanted to make sure we are clear in that I do support Black media. I do support media. I support all media, but in particular, I support Black media.
That might be able to be done if this place still exists and looks the same as it did. I have no idea whether it does. If the report is descriptive enough that somebody who has artistic talent can draw out a really good diagram, that might be a solution as well. But I mean, I don't know. I doubt if just I don't know. So, okay.
That was just something I wanted.
All right, well.
And I'll go in detail about if I have to tomorrow.
All right. Y'all are on notice of that, and to the extent you think you might use some substitute for those photos, if those photos cannot be found,
I don't have any.
talk to, or what do you think? I mean, do you think you'd probably just have a witness describe it, an eyewitness describe it?
Yes, I
Okay,
can.
well, that's
I can.
fine. All right. Okay.
So Miss Latner's is a witness that we've called and have had to call at different times regarding the 911 calls. I don't know that there are any objections to them. There have in the past been some objections to 911 calls, but
To the contents of them, or to them coming in at all without?
to the contents of some of them.
Okay.
We had a long discussion. Judge Glanville excluded part of a 911, one specific 911 call because it was not for an ongoing emergency, and it identified a person, in that case, Mr. Williams, but the speaker, the caller, 911 caller, was not available, so we could not confront. So it was a confrontation clause issue, is what the state's talking about. If I have the 911 call, I will look at it and make sure that there's no issues. And that's under Pitts, Pitts versus State of Georgia. I believe it's a 2006 case. It was written, I believe, by the Honorable Justice Sears. It's cited, I know it's under old law, but it's cited in 2023 or 24. It's a great opinion, actually, by the Supreme Court of Georgia. But I think that's what Miss Love is referring to.
No, we were talking about the ones that are coming up. We're not revisiting the ones that
Right,
are already.
right, yeah.
What I'm
But
saying.
okay, so as to whatever other 911 calls, y'all know what other 911 calls they intend to introduce?
Those are the ones that are listed on the list that the court has in front of it.
Which I just have this exhibit list that doesn't have any detail. It just says 911 call.
Yeah, that's
Oh,
what I
okay.
have.
So,
I don't have the
okay.
new list you
So-
shared.
The 911 call and the CAD report from 1511.
Oh, okay. I do. Yeah. Club Crucial, 1428 Adele and 1903 Drew. Okay. So y'all, the defense, know what all of those 911 calls are going to be.
I could link it up. Yes.
All right. And you're going to be getting that more detailed exhibit list over anyway. So, I mean, whether you have an exhibit number for them or not, you could be like, 1223, 1248, 1255 or whatever on whatever date. And then they'll be able to search their discovery and find it and figure out for me whether there is any objection to the 911 calls, content or otherwise.
Yes.
Okay, so that might be something we have to deal with. All right. Yeah.
CAD reports. I have a case for the court. I have to just put my finger on it, but certain information in CAD report is also confrontation clause. I'll get you the case.
All right, and then point out for me, as to whichever CAD reports are going to be used, what is objectionable. All right, thank you. All right, it looks like the next few are not necessarily any objections other than the normal ones in a trial. How about, is this number 26, at least on my list, Tyrone Dennis, is he just has a lot of different types of evidence listed next to him. Is he law enforcement?
He is.
Okay.
He was one of the lead detectives
Okay.
that investigated that assisted in the investigation regarding
Oh,
Mr. Thomas.
right,
Later
yeah.
on.
We've heard about him in our videos we've been listening to. That Dennis. Okay.
Yes.
So, is he going to be, do y'all know generally what evidence he's going to be testifying to? And do you think you're going to have objection to it that we can take up beforehand?
So he is also, in addition to being a fact witness, he's also one of our gang experts. I think.
Okay.
I don't know if that was brought out before, but as it relates to the social media, some of the social media posts between Mr. Garlington and defendant Williams.
I don't think Ty Dennis was
we ain't going back and
qualified
forth
as an
social
expert
media posts.
witness
I think,
per se for the testimony he gave
some of them
early
we may
on.
have already put in, but the social media posts between Demikion Garlington and Mr. Williams, I'm screaming 30, fuck a blue jean bandit. Other social media posts that we've specifically identified and I'll send over.
Okay.
Between Mr. Garlington, Mr. Stillwell, Mr. Arnold, and Mr. Kendrick. Photos of the gun recovered by law enforcement from Mr. Kenneth Copeland that belonged to Quindarius Zachary. A photo of the gun Mr. Zachary was arrested with on May 7, 2015. The video of Mr. Arnold getting into a fight with Kelvin Watts at Magic City on September 30th, 2015, which led to the subsequent arrest of Mr. Kendrick, who was in the car with Mr. Arnold. Following that fight, and at which time Mr. Kendrick was found to be in possession of a gun, and it led to the revelation that they were going to retaliate against members of a rival gang at this apartment complex.
Okay. All right. And then you also have music next to that. Is he going to just testify about certain songs, or what's that going to be?
He would intended to play portions,
Okay.
not whole songs.
Okay. And he'll give his gang expertise about what
Yes,
all that stuff means. Has he already testified once? Has he been qualified already? Okay.
Yes.
All right.
So
Yes, sir.
a couple things about the state's proposed evidence about through Mr. Dennis or Investigator Dennis. With the music, I'm interested. Is the state planning on playing videos, audio? How is that? Are they proposing, of course, over our objections? And
Right. And a lot of that's already been ruled on. Let's find out. Did you intend to play video or audio when or whatever, I don't know what his rank is, Dennis is going to be testifying?
So it's audio, and these are the overt acts that we have listed. For instance, Act 78, 60, 74, 95, 97, 103, 125, and 129. So we would be playing the audio portions of the audio.
so strictly audio, no video, no pictures.
No, I can't. I didn't say that. I also said that we would be putting in the described social media post.
Oh, yeah. No, he's not asking about social media. He's asking about when you're going to be playing clips of songs.
That's right.
Is that going to be just audio, or is it going to be video also? Is that the question?
Yes, and if there's video, I mean, we've discussed, from my recollection, and I wasn't the one litigating a lot of the
Right.
free speech, First
Right.
Amendment issues here.
Right.
But if there's video, there's certain things in a video that could be problematic to be introduced in front of a jury as well. That's why I'm inquiring. Are we confining it strictly to the words that are spoken?
No. So when we have, so what I didn't make the distinction on my list of which ones we will be entering the videos of. So I will speak with Mr. Sharp and whomever else wants to be involved in that conversation and identify the videos that we will put in as or.
Okay, so this witness is within the first 30, and so by
Midnight. You said?
the end of Friday, you need to have details for what specifically, not just music, but, you know, a video of whatever the name of this song is, or, you know, a 2-minute clip from this song, and here's the minutes that are included, and audio from whatever other song. Detail it for them so that then they can make detailed objections.
And Your Honor, also just to give the court a heads up, 87 Lima is operations planners PowerPoint. I don't have it in front of me, but I'm very familiar with that PowerPoint. That PowerPoint includes all sorts of conclusory language, all sorts of additional information that is not relevant to this case, all sorts of commentary from it written down on the, I believe it was intended to be a PowerPoint to other law enforcement. That's my understanding. I could
Is
be
that
wrong.
PowerPoint that Dennis is?
I believe so. And I understand that the state's intending to call him as an expert, but you know, hearsay and an expert can't be used as a, you know, mere conduit to get into hearsay and other inadmissible evidence. And there's a lot of, I'm saying I know I have numerous objections. And
All right, is 87 Lima already in evidence or no?
No, I don't think we've introduced it.
Okay.
Evidence, but they.
Your Honor, when we were served with this, I filed, I'll get you the date. I filed a motion challenging the admission, and my memory is Judge Glanville said he's not letting that in and asked the state, and they said they were not using it. Now, if that's wrong, I apologize, but I'm pretty sure that's
Okay.
accurate.
All right, so
I'll check back into our notes because I don't have memory.
Don't
of that
remember.
particular
Okay.
case.
All right,
But
just check
I'll
on that one.
back.
Thank you. See, this exercise may be boring, but it's helping everybody.
She tried to slip it in. She tried to slip it in.
All right, and then there's Arnold, Munson, Kilgore, and Underwood would take us through 30. And it doesn't look like there's, other than maybe Arnold. He doesn't seem to have an interview. He just has jail calls. Is that right?
Jail calls and the plea agreement.
Right. Okay. And the plea agreement would be kind of the same issues as the other plea agreement we were talking about
Yes.
previously. Okay. All right.
And then some social media.
Okay. All right. All right. So y'all get together on what I've told you to get together on. As far as I know, outstanding, waiting on an order from me are Mr. Stillwell's renewed motion for fair trial, which I'm finished but have not filed yet. And then Mr. Kendrick's supplemented motion for mistrial, and then Mr. Williams. I don't know if it's two different ones, Mr. Steele, or just one and two amendments to the motion to disqualify the prosecutors. Is that two different things, or am I just supposed to?
You ruled on one? Because I said I.
The earlier one, but then you sent 2 more.
Okay, I remember one,
Okay.
but I'm sure you're right. But I remember one about ethical concerns.
All right. And as far as I am recalling, those are the only outstanding motions that need ruling from the court. Does anybody have a recollection of anything additional? No.
It doesn't sound like the judge is going to.
All right. Any
rule on
other matters that you
mistrials.
need to bring to the court's attention or that we can deal with right now before we adjourn for the day?
Your Honor.
Yeah.
Mr. Adams, you're correct. There are 2, but there's an amended additional motion that was filed on August 6th at 3:53.
Yeah.
And then there's an additional motion to disqualify lawyers Love and Hilton, which was filed approximately 56 minutes before that. But all I added was, all we added was a footnote. That's the only difference.
Okay. So basically one just supersedes the other then. So I can look at whatever the latest filed one is and
Yes.
that'll deal with it.
That's
All
correct.
right. Thank you for that clarification. Okay. Y'all have got lots to do. Thank you for your hard work thus far. I will see everybody bright and early on Monday morning at 8 a.m. All of the attorneys should already have orders for early entry into the courtroom. Does anybody need one? Mr. Howell, will you be with us Monday or will Mr. Weinstein be back with us? Okay, and he should have one. And our defendants are already with us, so. Speak into your microphone, please.
We've got an old order from Judge Glanville. I'm
Okay.
assuming, I mean,
He's still our chief judge, and it probably, does it just say through this trial?
I don't know.
All right.
I'll have to look. It-
I'd
it does
imagine
say
those are
through
still
Okay,
in effect.
all right.
Okay. All right. So I will see everybody on Monday and please do the homework that I gave you. All right. Thank y'all.
Well, there you have it. So now, what we just heard was a series of requests for a mistrial. It was a mistrial and by request by Attorney Brian Steele. Then it was supplemented 51 minutes after he filed the first one, and then you have Weinstein filed one for his client. And I'm going to say pretty much it's why I didn't see the judge's order, but it sounds like this trial is not stopping. She's just probably articulating why she's not ruling for a mistrial, but it is clear just based on the way she is being pretty much steadfast in her belief that this trial should move forward. I don't know what is it going to take for this trial to be declared a mistrial with this particular judge. I saw some comments where people were saying she's the female version of Glanville. Well, she has a lot of respect for Judge Glanville. She's made that very clear. And anytime there was any arguments that appeared to pull Judge Glanville into the argument, she kind of pushed back on it. Even with the line of questioning that was happening with certain lawyers, she said, "Well, when the witness was on the stand, even when Caleb Bumpus was on the stand." And ladies and gentlemen, I'm gonna tell you something. Caleb Bumpus, boy, that's interesting young lady. She and I was going back and really go back and forth. I've said a few things about how I viewed her testimony, and she responded. And one of the things that she said, and you saw Caleb Bumpus' testimony when she had testified that she didn't know she was in the ex parte hearing until she learned it from Brian Still. She testified to this, but then she responds to my tweet and says, "What she didn't mean it literally. What are you talking about? It came across as literal. You was on the stand testifying to it. So what did you mean? You didn't know until you talked to Brian Still, and then you say you didn't mean it literally. Well, you didn't tell that to the judge while you would in your explanation. So a lot of the stuff that I saw her do during her testimony was not what I saw her do as she was doing her lives. And it was I don't remember, I don't know. I'm like, this is an attorney. And this is an attorney that was encouraging her people to pretty much hit the, help build a channel. But I don't know. I don't know if I don't know if she's going to get referred to the bar association, but there was some things that was going on that it was kind of weird. And then she retweets that she wants to get a YSL chain. And I'm like, wait a minute. What are we talking about here? What are we talking about here? And then she files for Rule 22 and she gets shut down. Okay, so and then I asked her on Twitter, so what do you need a Rule 22 for again? For those who don't know what Rule 22 is, it is a request to the court to be able to use electronic equipment, for example, tablet, phone, recorder, camera, video still. And when I looked at the request and her reason for asking for it, I knew that the judge wasn't going to grant it because what angle of the courtroom did you need that's not being shown already? And the other problem here for this trial is there are only a few seats there. There are only a few seats. There's not a lot of seats in the courtroom designated for the members of the press. There is 2 rows. I believe 2 rows. The first row is where the cameras are on, myself and the pool camera, because I'm not shooting pool, which means what I shoot, I own. What the pool shoots, they share with everyone. So I don't know if she thought that the judge was going to grant her this attorney who, and just think about this for a second. You were representing for a small period of time the star witness. And how did it go from you representing the star witness in this ex parte hearing that you claim you didn't know anything about to wanting to be a part of the media per se in a case that you were called as a witness on this stand to testify as to what happened? It made no sense to me. It made no sense to me. And while I get it, you got caught up in the moment, and this is, your name was ringing bells because you were a part of the hearing, the ex parte hearing. I definitely didn't think that it was necessary for you to have Lil Woody on your platform. And I said this earlier on. I said, this is going to come back to bite you. And it sure did. It really did. And then she was using statements like she used the word unalive while she was testifying on the stand. I'm like, why are you using YouTube phrases when you know the term murder is murder, a homicide, murder, but you're using unalive? I'm like, did she just say that? Like, am I really listening to her say unalive? Like, there was just too much going on there. Let's see here. Let's see here. I'm going to read some comments here real quick here. He was trying to learn how to unblock, etc. Okay, let me read some questions here real quick. Yeah, I missed some things here. Hold on. Oh yeah, Kia Elder. Heck yeah. Man, I'm gonna tell you something. Kia, I actually interesting. I wasn't on my live, but I don't know. I was watching Lead, and it was in real time. And she joined. She became a member and joined on. But before she got on, he was going in on her. I'm like, okay. It is. It is. It was really uncomfortable watching her testify because she was loud and certain when she was talking to Lil Woody, and she was all over these platforms. But when she had to get on the witness stand, and Adrian Love, boy, that was a moment. I'm gonna tell you something. Adrian Love really had fun with her. And she kind of when she was on Lead, she kind of tried to say that when the investigator got on the stand, it kind of validated what she said. Well, it really didn't validate what you said. I did have a little issue with what the investigator said, but it didn't validate or make your testimony seem more, I want to use the word credible, but this, I don't remember. Can you repeat the question? You have a Juris Doctor degree. You're an attorney. You practice criminal law. You worked in the prosecution office. I did not expect to see this type of response coming from someone that is an officer of the court. And they played it too. Earlier that same day, Melnick, who actually represents Woody, as well as the chief prosecutor, deputy chief prosecutor, got on the stand. Well, Melnick didn't have to be sworn in, and I don't believe the chief prosecutor had to be sworn in either. He even mentioned, he said, listen, I'm an officer of the court, why not have to be sworn in? But Weinstein made sure Caleb Bumpus was sworn in. Raise your hand. They treated her like a witness, like a real witness. I don't know why. I thought that was interesting that they made sure she was sworn in when she gave the testimony. And I think it was kind of dangerous for the defense to hang their hat on what she had to say, knowing what she was doing online, knowing the whole exchange with her and Lil Woody as it related to was the transcript complete or was it missing something? And the judge told her, you have a duty of candor to inform the court if there's something that was missing from the transcript and you didn't. And you guys know that she was essentially online suggesting, implying that something was missing from that transcript. We now know that nothing was missing from the transcript. And that was part of the reason while the judge, Glanville, didn't get recused for that per se, but that started the whole ball in motion. And do I believe she was the quote unquote leaker? Absolutely. Absolutely. I believe she was the leaker. Why do I believe she was the leaker? Well, it was certain questions that the judge, when the judge start asking you questions and you're the witness on the stand, that can never be good. It was another case I covered last week, Gwinnett County. The judge turned to the lawyer, first the lawyer questioning the witness on the stand, a series of good questions. They were to the point, but the judge interjected and said, I want to start asking questions. Well, Judge Whitaker started asking her questions. And Judge Whitaker wanted to know from her, and judge can do that. She's the judge, she's the referee. She wanted to know exactly, for example, when did you come out and talk to the lawyers, and who were there? Who was in the hallway when you was talking? Like basic stuff like that. You don't know how many people were there. Oh, those, like you walked out there, you had a meeting with these lawyers after you left the ex parte, but you don't remember who exactly was there. Well, I don't think it was anyone else. Who else could it have been? It wasn't Melnick because he was on vacation. Who else could have been a part of that? And I doubt very seriously it was any of the deputies. So I would conclude, in my opinion, I think she was the person who went and ran her mouth and said what she said. And I don't know if that was the smartest thing to do versus maybe talking to Melnick and perhaps seeing if he wanted to authorize you to now share this information. It wasn't private. See, the thing is, Judge Glanville, didn't say that she couldn't talk about this. But whatever was told to Brian Still and other attorneys, it started the whole judge. There was a secret meeting and we weren't invited to it. Judge, who told you? Well, Judge, I'm not going to get into that. I want to know why we weren't informed that there was a secret meeting. Well, we'll talk about that after you get out after you handle these 20 days in jail. Well, that didn't happen. But I believe Caleb Bumpus was the one who started all this, in my opinion. I don't know. You guys can think others. That's just my opinion, just based on watching her performance on the stand, as well as watching what she was doing on YouTube. And then she wants to get to, I want to rule 22. I want to be in the courtroom. I want to be part of media. Lady, stay in your lane. Calm down. Calm down, lady. I could have showed you how to argue for your rule 22. You really didn't need it, but I could have, your argument, trust me, you made the wrong argument. I will tell you how you make the argument. That was the wrong argument to make because you didn't want, it was about watermarks. That's not the reason why. Because the judge, the whole purpose of having a pool camera in the courtroom so you won't have a cluster of cameras in the courtroom. That's the whole purpose of that. You should have known that. You criminal defense attorney, you would know that. You should, you practice law in Georgia. You didn't know why the case is pooled, so you wouldn't have a bunch of cameras in the courtroom. And Judge Whitaker even questioned that there were the amount of cameras that are in now. Because my camera, Sylvia has a little camera, it's really a nice little cute little camera. And then you have the pool camera. And sometimes AJC come in and I'll take their picture and that's it. But you want to be another camera in there for what reason? Or you could have said, what she could have did was ask for a Rule 22 so she can use a phone where she can live tweet, where she can tweet from the courtroom or do some kind of social media. It's different ways, but you didn't need a camera in the courtroom. You didn't need it. For what reason? You didn't need it. Do I have a hamster? I probably need to. Sharpie. I gotta do something with this chair. I'm gonna spray this chair. It's my chair. Right. Judge can question. Judge can clarify. Exactly. Let's see here. Yeah, I'm gonna fix that. I'm gonna take care of that. I'm gonna take care of that. Do I have a hamster? It's funny. That's funny. We're gonna fix that. We're gonna fix that. Hold on. We're gonna fix that. Hold on. Stand by. Hold on. We're gonna take a 1 minute break. Don't go nowhere. Stay right there. Don't go nowhere. Okay. Oh, okay. 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 What I'm saying is, when she said that, I was like, I had to like, you didn't know that it was ex parte when you didn't see the defense attorneys in the room. If you're not in the courtroom and you're in the judge's chambers with the defendant and sheriff deputies and no members of the defense team, and you've been a criminal defense attorney for 5 to 7 years and you didn't know that was an ex parte meeting, I've spoken to several attorneys and they've all said that, Dennis, she had to know that was ex parte meeting. You had a sworn in witness in the room. You came to represent him for you represent him for the Mr. Melnick. So what part of you didn't know that? That just, and the judge had, and you saw how the judge reacts. Well, you didn't know this? How long you been an attorney? Oh my God. You remember, you remember Olga and how the judge had to remind Olga, or just said, this is the Cardi B case where she basically said, this is first year law school stuff. Like, what are you doing? And I'm not trying to give her a hard time. I like Kayla's drive, but I would be probably honing my craft rather than trying to get into an area that she's not so versed in. Because if you got to prepare your client to testify on the stand, that was not good. It wasn't good at all. It wasn't. And, let's be honest, it was just too much YouTubing going on there. Just too much. I mean, I like her, so I'm going to tell you something. That could have been my daughter. But no, I would have definitely said, listen, honey, don't ever do that again. You went to school, you got your JD, and make sure this is what you want to do, but make sure you be thorough with it. And the crazy thing is, she was sitting in the court. She was sitting in the courtroom working. I guess had her sitting beside her because that's the only way she would be in the court, because she has to sit next to the media. You have to say that you're part of media. So, and you heard the judge say, in her decision, you just can you can pool with Sylvia. So what the judge basically did was made Sylvia and her pool. So they got to share the footage. I don't know if Sylvia wanted to do that, because if Sylvia wanted to do that, then she probably didn't need to request a Rule 22. They thought they was going to get an additional one. The judge said, no, I'm not doing additional ones. I got one from here. I got one from here. I got one from here. So that's probably why the judge just made it. Sylvia has to share her footage with her, but she didn't really have to do that. Well, I guess she would, because while this case is being pooled, if you're part of the media and you're actually in the courthouse and there is and you have a laptop or something, you can grab the footage. It'll be post footage, or you can do like I'm doing, is setting up the device in the media room where I can stream it and share the link. So it's different ways of doing this. But the way she was doing it, it was like, oh my God. I didn't see it, guys. I didn't even see it in real time when she was requesting that. I didn't find out until like 4 days later, because I was covering another case. But someone shared it to me, sent it to me on Twitter, but I'd never even seen it. I'm like, wait a minute, what? She did what? When I looked at the footage, I was like, oh my God. So that's why if you go on my Twitter page, my response is, it may look dated, is because I only saw the footage 4 days later. So it happened prior, and no one really tagged me and said, did you see this? And that's significant because I'm one of the few who has a Rule 22 in the courtroom. So it was just funny. I just thought it was interesting. Oh no, the Weirdo didn't block the number. No. The Weirdo didn't block the number. Um, uh, the Weirdo had my number because I was on. This was maybe about 3 months ago. I was on that person's call in, talking about the case, and I think it probably was because I didn't get back on this platform. I didn't have a need, an interest, a desire. And so he said, "You don't support black media. You don't support black media. Oh, just because you asked me to get on your platform, I'm just going to go." No, I'm not doing that. I'm not doing it because I see how you rock on your platform. It didn't fit my schedule. Let's just say it didn't fit my schedule. We'll just leave it at that. But I also want to say this, ladies and gentlemen. I apologize. I haven't been on YouTube probably almost a week and 2 weeks now, like heavily. But I'm back. I'm trying to read some of the comments here. Man, Aaliyah, boy, I tell you, that was crazy. There was some things I saw. I ain't gonna try. I know what I saw. I'm not gonna really trash her. I'm gonna leave. She didn't anticipate that, and she said she didn't know she had to get on the stand, and she has attorneys, so they should have probably prepped her. But the judge wanted her to go in 5 minutes, so she does have attorney. She's represented by attorney Gabe Banks, who represented her in the initial hearing. So she has an attorney. Let's see. I know you missed me. Hey, we back. Did you guys see the video circulating of Kamala? Let's say Kamala at the Soul Train dancing. Well, some people say it's not. A lot of people say it's her. We don't know. She's gonna have to come out and say, "No, it's not me." But I thought it was interesting. I posted in my stories on Instagram. So you go to at Mr. Dennis Byron on Instagram. I did post it in my stories, but I thought it was interesting. It was cool. She was having fun, and it did look a little like her. Well, they dug it. The internet is undefeated. They dug up a video. It was back. It looked like it was about 30 years old, 30 or 40 years old. So I don't know. Let's see here. Did you guys see the Michigan rally where her and Coach Walsh was at yesterday? I thought she did really good. The crowd was a very big crowd, very big crowd. I might be heading out to DNC anyway, so I know the crowd's gonna be crazy. It's probably gonna be tired. There's gonna be so much going on for the DNC. So much going on. And we have like 80 something days. And the fact that she raised over $200+ million, and the turnout is crazy, and the youth are coming out, and I mean, and then you got the governor of Minnesota. Shout out to Lovely T. She's in Minnesota. I think this is a good ticket. I was thinking that she would pick Shapiro, but then there's some issues there that I thought would be a problem if she picked. Let's be honest, she picked the Jewish governor in light of the fact we're kind of indirectly involved with the whole Israel Hamas situation. I thought picking him right now would probably not be the best pick for a VP, and it would probably, that would probably alienated some of the Muslims in America. So I think that was a smart move. I think I didn't even think about this guy being the pick, but I think that if she would have picked Kelly, that would have been okay, but this guy, Walsh, has executive leadership. You know, being the governor of Minnesota shows that the guy, you know, he's been battle tested, so to speak. So I thought that was a good pick. But we're here to talk about politics. You know what we're here to talk about. With that, ladies and gentlemen, we will be back. We'll be back for our next live. Hope you guys enjoyed what you've seen, but we got some more coming up. And I want to bring this court case up there that I covered. Waiting for the judge, hasn't given a ruling yet on that case, but I thought it was a custody case. They reached out to me, and I decided to cover it. It was very interesting. So many twists and turns. You know, talking about it was live mention of law enforcement. It had a lot of stuff going on in this case. So I don't know how the judge is going to rule, but the ruling should come down really soon. But we'll talk about it once the ruling comes down and we share some of the content. With that, ladies and gentlemen, I do appreciate you coming in, and I'll see you guys on the next live. Until then, we're gonna make sure the light is. Let's set up the lights. We're gonna set up the lights. With that, ladies and gentlemen, we'll see you on the next live.